About one of our speakers who's actually, assuming he makes it on the board, this may be one of the last times that you hear from him as a panelist, because typically our board members are organizers and not panelists. So it's a great pleasure to have John Sarno with us today. John, I believe, is a lifelong New Jerseyan. Was an attorney, is an attorney. He's the president of the Employer Association of New Jersey, which is a tremendous resource for businesses and other employers throughout the state of New Jersey to get information, up-to-date information on HR practices, legal practices. John has a tremendous organization and does a great job. And he's particularly qualified for tonight's meeting about COVID vaccine because he is on at least one, I know, task force that he was put on by Governor Murphy with regard to the COVID pandemic response, and is doing incredible work with that. We also have another repeat presenter with us today, Stephen Cohen from the law firm of Selikoff and Cohen. Many, if not all of you, are familiar with Stephen from the work that he does, one of the most prominent union side attorneys in the state of New Jersey. Stephen is a representative of the State Police Benevolent Association, the New Jersey Education Association, many other unions, and he's here to share with us the labor perspective and just common sense perspective of where we're going with regard to COVID vaccination policies. So thank you to both of you gentlemen for being here. What we're going to do is a bit of a back and forth where we start off and we're just going to, we've got different topics within the realm of COVID vaccine policies. Not all of them are necessarily mandatory. They could also be voluntary. So we're here to basically talk about the entire universe of what employers are to do with the existence of the COVID vaccine. What can they do? What can't they do? What should they do? So, just to set a baseline for our discussion, we will start with the topic of mandatory vaccination. Is it legal? Why don't we start with that, John?
Oh, thanks. Thank you very much, Jonathan. It's delighted to be here with you in the group. A privilege to be considered to serve on the board. Certainly, and a privilege to be here with Steve Cohen, who is one of the premier experts in the state of New Jersey. So thanks very much. And I'm grateful to be able to share what I know about the topic. So in terms of, I think, the base starting point would be that the final word on the vaccine, which is the CDC Advisory Committee, has pronounced the two vaccines that are currently on the market, Pfizer and Moderna, have pronounced them safe. Safe for the public, safe for nearly every American adult, with few exceptions to those who may have severe reactions to the contents of the vaccine. So that's the starting point, I think, for our discussion as to whether we should require, employers should require, or do a voluntary program. The final word is that it's safe. We're pushing now 2 million first doses and over 500,000 second doses. And so the implementation of the plan is slow but sure. And it's a totally voluntary program. So there's no mandate. Unlike, let's say, where healthcare workers are by statute required to get a flu vaccine on an annual basis, the COVID vaccine is totally voluntary at this point. Can it be required? The answer is yes. Of course, we'll be talking about that in some detail. I'll simply say, and then I'll turn it over to Steve, that the guidance that we've gotten from the Equal Employment Opportunity Commission, which interprets both the Americans with Disabilities Act as well as Title VII, particularly the ADA. Vaccine in and of itself is not a medical examination. It's not a medical intervention. And that's really the starting point, at least insofar as the EEOC is concerned. Employers can require the vaccine.
Steve, why don't you let us know your response? And also, a lot of people are here from the government sector, the public sector. Maybe you could also let us know if you think that maybe it's legal in the private sector, not in the public sector, question mark as to each. What are your thoughts, Steve?
Well, first of all, it's an honor to be here tonight and to be presenting to this august group and with John, and I'm sure we're going to have quite a conversation. The issue of whether or not the government can mandate vaccination goes back quite far to the beginning of the 20th century. There was a case, Jacobson versus Massachusetts, where the Supreme Court of the United States said that it was that Massachusetts, which had passed a law mandating quarantining and vaccination for smallpox, was perfectly legal, that the state could use its police powers to require such a thing. And our own Supreme Court, New Jersey Supreme Court, didn't visit that topic until 1948, ironically, in a school district case, Sadlock versus the Board of Education of Carlstadt, which discussed compulsory vaccination of students. To John's point, right now it's voluntary, depending upon where you are. Are you a employee in the private sector with no union, employed at will? Are you an employee in the private sector where there's a policy that's enforceable? Are you an employee in the public or private sectors who is unionized? And as in many of the legal issues that we face on a day-to-day basis, these all have an impact. I am sure, in fact, I'm certain that the employers would love to have a state statute which would require the COVID vaccination, because that would eliminate many different issues, evaluating certain and give employers certain cover. It's ironic because we're talking about an issue, frankly, where management, labor, and employees should all, frankly, be pushing together on these issues, because we know that we need mass vaccination in order to create some form of immunity from the COVID virus. So the more people who are vaccinated, the better. And in the workplace, extremely important. So I think that when it comes to governmental employees, there's a real issue, because we know that, for example, in New Jersey, we have the local 195 case, which is the case for negotiability, which talks about, the three prongs of the test. One being, does the subject matter intimately and directly affect the work and welfare of public employees? The second one being preemption, and the third being whether or not negotiation on a particular topic would create significant interference with the implementation of governmental policy. And so, normally when we're talking about Local 195, we're talking about a statute or a regulation. But here, at this point in time, we have an executive order from the governor. And the question really is, what is the legal status, frankly, of an executive order in relation to, it certainly doesn't arise to the level of a statute or regulation, but we do know that it is enforceable. Many of you will recall, for example, the gym down in South Jersey, which refused to close its doors during the height of COVID in the spring. And the Attorney General's office went to Superior Court to get an order to enforce the executive order, and ultimately the owners of the gym were held in contempt. So it can be utilized, but right now it really is voluntary, and for employers, and I'm sure we'll get into it, how that dovetails with the EEOC guidance on voluntary programs. So I'll leave it at that for now.
Thanks, Steve. What I'll do real quick, since I have the share screen up, show the New Jersey School Boards Association. If I could actually get this, it seems not to work. I'll just tell you about it. New Jersey School Boards Association, of which Kurt Rabovich is on our board, put out a piece that's on their website that you could find. I actually spoke about this at a school law convention last week, so I know they approved me to make reference to their material, where they took the position. I was a little bit surprised to see this, that there needs to be legislation before, at least in the public sector, that teachers can be mandated to have the vaccine. So there's a possibility that we'll have to wait and see if there's legislation, but it's also a possibility of an executive order. Obviously, a lot in COVID has happened by way of executive order. Do you see any of that in the crystal ball, John?
Well, I think the wanting that safety of a statute does make a lot of sense. There's a lot to unpack from Steve's remarks. The Jacobson case was reaffirmed by the Supreme Court in 45, I think. It was a Jehovah's Witness case challenging the mandatory vaccination of a child. There again, Supreme Court was very clear about the state's police power outweighing even the sincere religious practices of a citizen, and again, it was happened to be Massachusetts in that case. So, but there will be, and there are grounds for people to refuse the vaccine. Clearly, whether it's negotiable or not, what will depend on each collective bargaining agreement. Some may be broad enough to include it. Others might make it a mandatory condition to get the agreement of the union. But in either case, there are reasons, some legitimate, some not so legitimate, reasons for people to either conscientiously object or to refuse a vaccine. So then the question is, well, if you're requiring it, then, thinking it through its logical course, right? I think we can probably predict right now it's changing. Right now, the public opinion polls suggest that 70% of New Jerseyans, it's a high figure, say that they are either willing or probably going to, they're either going to or probably going to get a vaccine. So that's a dramatic difference from November of last year, when only about 50% of the people were saying that they were willing or likely to get a voluntary, vaccine. So public opinion is changing, but the recent Monmouth University poll, public opinion poll, Institute for Public Policy, suggests that there's a good 30% that we can predict, and perhaps we'll talk about what that profile looks like. But we can predict who's going to refuse, who's going to resist, who's telling us now, at least at this point in time, that they would not be willing to get a vaccine, right? So let's just assume for a moment that maybe there's 20 to 30% of the workforce who simply says, no, thanks. So, the employer is going to have to think this through, and no one wants to make a discharge decision, right? I mean, that's the last course. But push comes to shove. Question is whether, if you're going to mandate it, whether you're going to make a discharge decision. And of course, and we'll get into it, I'm sure, for those with medical conditions, we're going to need to reasonably accommodate, and there may be religious accommodations as well. So, but if you'd like, real quick, for those scholars and academics among us, this is a really great read. It's called American Contagions. It's a very short read, and it deals with the constitutional history of how we've dealt with pandemics in the past. It's really, I recommend it for those academics and scholars in the group. American Contagions, and for those of you who are really into the constitutional issues.
Thanks, John. The only purported scholars on here that I know of are, Bill Dwyer and Jim Cooney. And no, that's not true. We probably have a handful of others also. John Burton, for whom we named a scholarship if he's here tonight, and many others. So American Contagion, we could put that on our reading list. Steve, unless you want to respond to what John just said, I was thinking maybe we could shift a little bit to some questions that people are having from a legal standpoint that we're seeing frequently. Putting aside vaccine policies, people are getting the vaccine, right, and coming to their employer and saying, okay, I've gotten the vaccine. And now employers and unions and employees need to know what that means in terms of the policies that we've lived under for the past nearly a year now, right? So one of the things that we have in our outline is to talk about the CDC guidelines that came out, and whether employees must quarantine if they've been vaccinated and they're still exposed to COVID after getting the vaccine. So I'm gonna put that up on the screen, but don't view that, Steve, as something that you have to talk about. But just in case people want to check that out, I'm going to throw that on the screen.
Well, right. The latest guidance from the CDC is that if you have received the 2 vaccinations, you do not have to quarantine if you're fully vaccinated and it's been 2 weeks after the vaccination. You're within 3 months following receipt of the vaccine. And I looked into that a little bit today. That is because there really isn't a wealth of research on, how long the staying power of the vaccine. So they put it to the 3-month level, and then of course not feeling any symptoms. All of that said, as in the case of all the other changes on quarantining, the CDC isn't saying that this is the greatest. But the CDC, from what I've read, has been concerned that people have not been properly quarantining. They still feel, I believe, the research indicates they still feel that you should quarantine for 14 days. That's the safest amount. But they have tried to reduce it a bit simply because people were not following the guidelines. And they were hopeful that if they reduced it somewhat, that people would follow them. There were a lot of because of in a lot of industries, a lot of different employees, if they are forced to quarantine, as we all know from our experience in either representing employers or being neutrals or representing unions, that it's not so much that people don't want to quarantine, it's about how do they get paid if they do quarantine? You know, are they going to be eligible for various forms of you know, federal or state leave, or if they are not unionized, employer policies, or in a unionized situation, being able to use the various forms of leave in a collective bargaining agreement. So I think that's what the state is, Jonathan, with quarantining.
It's complex, no question about it. The governor's executive order is still in effect, and I know those of us on this call in this session get it, but based on the inquiries we've been getting over the last few weeks, I think the lay public seems to think that, you know, the vaccine literally is a magic bullet, and what it is that it's a tool among the other protocols, right? So the executive order is still in effect, which deals with working from home where practicable, social distancing, mask wearing, disinfecting, travel advisory, among other things. And then the executive order incorporates the CDC guidance, which is extensive, which includes the quarantine provisions. And I can tell you that employers are quarantining. They're directing quarantines. Now, what Jonathan and Steve has just shown us is the CDC trying to create a little bit of an incentive for people to get vaccinated, and so that the employer may be able to have a reduced, because after all, if I'm vaccinated, I still can transmit the virus to you, right? So simply because I'm vaccinated doesn't mean that when I come back to work, I'm still going to have to fill out the questionnaire. I'm still going to get my temperature taken. My employer is still going to ask me about my symptoms. And then there'll be a decision made, right, based on maybe not the full 14 days, maybe not 10 days, something more manageable. So there's no question that we're still quarantining. With regard to, you know, how people are going to get paid, well, New Jersey, depending on how long, someone might be eligible for short-term disability insurance. Someone may be eligible, obviously, for sick leave. The federal sick leave has expired unless employers have continued it through this month to get the tax break. Employees are still getting paid because there's various ways to do that. But the employer is still quarantining.
So real quick, just for everybody who's paying attention, if you don't know what John was just referring to, until December 31, since about April, there was in place the Families First Coronavirus Response Act. Some people call it FICRA, some people call it FFCRA, depends if you're someone who tries to pronounce abbreviations or not.
Right.
And then there's also the EPSLA and EFMLA, or these other things. But the gist of it, I guess, is that now, because these these were modifications, temporary modifications to the Family Medical Leave Act that have since expired on December 31. But if you're a private sector employer, like many of the members of the EANJ are, and you're not paying taxes, like the nonprofit, excluding nonprofits, if you're a for-profit company, then you could benefit going forward, because you can say, okay, we're still going to provide this type of paid leave, and the government will give you. I don't even think the government spent the amount of money that they budgeted in terms of paying employers back for the amount of taxes that credits that they allocated. So for whatever reason, employers weren't taking advantage of this when it was law, and now that it's voluntary, it's still out there. But in the government sector, I know a lot of the clients that we represent were looking at this. This is an unfunded mandate, right? It doesn't do us any good. We don't pay taxes anyhow. So to the extent that we get a tax break, there's no tax break. So there's a question in the chat, which I think is a nice segue to the next thing we were going to talk about, is the EEOC considerations and guidelines, which is a question that I think is coming up a lot from employees, unions, and employers also, which is, are we entering into a bit of a big brother world when the employer all of a sudden, we know that the ADA is in existence. We know that there's EEOC guidelines that have been in place for a long time on a lot of different things. But now all of a sudden, there's an executive order from the governor that, when you come in, I can take your temperature. I can ask you if you've had exposures to other people with COVID, and all of these other things. And also now, I guess I'd like to know if you had the vaccine or not, because if you've had the vaccine, that may affect how you have to quarantine, et cetera. So before we jump into the EEOC guidelines, I just want to read a question from Brady Montalbano Connaughton. She asks, can an employer require evidence of employees having received the vaccine? If so, does there need to be redaction of any identifying information? If the employee refuses to provide such evidence, does an employer have a right to follow up or ask questions, or does that implicate ADA/disability/medical disclosure concerns? You want to try to answer that question and take it into the next topic, Steve?
Sure. Can you repeat the first part of it?
Yeah, why don't we take it in bits, because there's a lot to unpack.
What was the
there.
first part?
The first part was, can an employer
Yeah.
require evidence of employees having received the vaccine?
I do believe that an employer can do that, consistent with the EEOC guidance, because the question of whether or not an employee has simply received the vaccine does not require the employee to divulge any medical information, or for the employer to receive any medical information. It's a simple question of whether or not you have received, you have taken the vaccinations or not. Okay, now let's go to the second part of the question.
So the second part says, if so, does there need to be a redaction of any identifying information?
Okay. Well, first of all, I think if you're simply saying that you received the vaccine, I don't think that you have to redact it. In fact, I think where that would wind up is probably in the employee's confidential medical file. Okay. The larger question may be, if the employee says that the employee did not have the vaccine, or the employee refuses to answer the question, then the next inquiry, I think, is whether what assumptions can the employer make, and can the employer conclude legitimately that because the employee has either failed to take the vaccination or declined to answer the question, does that pose a direct threat to the health and safety of individuals in the workplace? The EEOC has kind of defined what it views as a direct threat. And it does include a determination that an unvaccinated individual will expose other people to the virus in the workplace. The EEOC says that to determine whether a direct threat exists, employers should conduct an individualized assessment of 4 factors. And let me stop right there and say that when you talk about accommodation issues, whether it's disability accommodation or religious accommodation, it's different from disparate treatment or disparate impact, okay? Because in disparate treatment or disparate impact, we're talking about people all being treated the same. They're all treated the same. When you're talking about accommodation, it's different. The fact that somebody else was treated the same as you for purposes of of Title VII or the New Jersey law is irrelevant. What really matters is whether or not the employer gave individualized consideration to either the nature and extent of the disability or the sincerity of the religious belief and the religious teachings and things like that. And we will get into religion. But the 4 factors that the EEOC uses is, number 1, the duration of the risk. Number 2, the nature and severity of the potential harm. Number 3, the likelihood that the potential harm will occur. And number 4, the imminence of the potential harm. And even if the employee refuses to disclose whether they have been vaccinated or says they haven't, that's not the end of the inquiry. Because now the employer has to give, in my view, whether in a unionized workplace or a non-unionized workplace, individualized consideration to this situation. Is it possible for the employee to be otherwise accommodated in various ways? Some employees will be allowed to take leave, for example. Others may be allowed to work from home. Others may, the employer may say, well, we can do certain things. We can put up certain barriers. We can make sure that you're not close to other people. We can put you in an area, as I've seen, where you have access, if need be, to a bathroom that's not used as much. There are various ways that an employer can work with an employee who refuse, where, as John has pointed out, masking, social distancing, all of these issues are a factor. It's in other words, what I'm getting at is it's not the end of the inquiry if the employee says, I wasn't vaccinated, or I'm not telling you, and the employer says, go home, you're done. It doesn't work that way. It's much more complex than that. And I'm sure John may have some comments on that.
Yeah, before I give
From
it
the
to John,
employer's perspective.
and address the rest of Brady's question, right here this is from the EEOC guidance from their website. I'll give you the link in a minute. But question number 3 is literally Brady's question. It's asking whether or requiring an employee to show proof of the COVID-19 vaccine is a disability-related inquiry. And of course, Steve is right. They say no. the funny thing about it is, the EOC is so sort of myopically focused, whereas Steve just gave you such a broad overview about things that you need to worry about. But what I find a lot of these agencies are very myopically focused on their charge. So the EOC's concern is always, is this going to give you information as the employer about a disability that you're not supposed to have? So that's, they immediately say no and get into that. They say there are many reasons why an employer might want to know whether you've been vaccinated or not. But I think this sentence is kind of telling, or in a way even funny if you imagine how it would work in real life. So they say, however, subsequent employer questions such as asking why an individual did not receive a vaccine may elicit information about a disability and would be subject to the pertinent ADA standard that they be job related and consistent with business necessity. It's kind of funny because in the real world, what are we talking about right now? Everyone's talking about COVID. Everyone's talking about the vaccine. On Facebook, oh, I just got my second shot, this and that. No matter who you meet, people are happy when they got their shot. So if you were to say to somebody, oh, why didn't you get the vaccine? Right. And it happens that they're, maybe they're on the older side or they're overweight or perhaps not, there's nothing special about them optically. But you say this question, now all of a sudden you're putting somebody in a situation where they might say, well, the reason I didn't do it is because I've got an allergy, or maybe a religious issue that they don't want to divulge, or something along those lines, which kind of gets back into the common sense. Yeah, John.
I mean, I get it, right? The EEOC is doing a cut and paste, but what's job related and consistent with business necessity is a lot of stuff. So let me just take a quick shot at how it may work in reality. So the employer has a policy, let's say, requiring a vaccine. That is not a medical inquiry. That's why you can ask for verification. And it's not a medical or disability related question. So you have a policy requiring the vaccine. Joe comes in, you ask Joe whether he's gotten the vaccine. If he says yes, then you say, fine, let me see the card. Shows you the card, everything is good. Joe reports to his shift. Not a problem anywhere there. All right, so now Jim comes and he's asked the same question. Did you get your vaccine? He says no. You ask, why not? Not a problem. You ask why? Not a problem. Because that follow-up is job related and consistent with business necessity. You're implementing your vaccine policy. So asking that follow-up question is not a problem. So now he discloses something. Still not a problem. Because let's say he has a medical condition. Well, that triggers the interactive process under the ADA. And then you determine, as Steve took us through, whether the person is a threat. But that doesn't stop the inquiry, because even if he was an imminent threat, you have to reduce that through a reasonable accommodation, which may be working from home. So it's all very, very workable. But what happens when now Bill says, well, I didn't get the vaccine because I didn't feel like it. I don't believe in it. I think it's nonsense. Well, then I think the answer is you have to choose between your personal belief or your job.
I've got a hypothetical for Steve that sort of foreshadows what we're going to be talking about in a little while. So I'm the management attorney. Steve, you're the union attorney. That's not that far-fetched. We negotiate a
No, I
sidebar.
don't think.
we negotiate an MOA or a sidebar agreement whereby employees get half a day off to take the vaccine. So ex-employee, let's say it's a teacher, utilizes that policy, takes a half day off, and then someone asks them, did you get the vaccine? And they say no. At that point, because they took the half a day to get the vaccine, but they didn't get the vaccine, is that now getting into the area of a disability related question? Because probably if you went down there to take the vaccine, but you didn't actually get it, maybe there was some question that was asked in the screening process whereby, they didn't think you were an appropriate person to get the vaccine.
Well, I think there's so many variables there, Jonathan. It could be exactly what you were talking about, and it would trigger a discussion about why that person couldn't, it could trigger a discussion about why that person did not get the vaccine, and whether or not some of the pre-vaccination questioning caused those who were, administering the vaccine to say you shouldn't receive it, in which case we go to Plan B, as John and I have just talked about, in terms of the interactive process and reasonable accommodation. On the other side of the coin, if you have somebody who, as John has described, who really doesn't care about the vaccine, but just thought they could take a half a day off and get a free half day off, that may trigger a whole different analysis as to whether or not, the employee misrepresented why they were going to take the day, and getting into, our normal discussion of whether or not that's something which would suggest employee discipline, that type of issue. That's what I see.
Okay. John, there's a lot of the EEOC guidance is about this issue of screening and asking questions. And I think there's sort of an outright piece of advice, if not implication, that employers would be better off contracting to third parties the COVID vaccination rather than having it done in-house. Is that a real thing that we should be thinking about? Or are they kind of off on the margins again?
Yeah, as a practical matter, yes. I don't foresee for the foreseeable future. I don't see any mobile clinics. Originally, we were thinking about, back in November, we were thinking about, the way employers do a flu vaccine. They have people come on site, and you can still roll it into your wellness program. And I hope we have a chance to talk about voluntary programs. But many public and private employers have, bring the flu vaccine on site, totally voluntary, and that gets you around potential workers' comp issues, right? Because if you require the vaccine and there is a serious illness, then that is going to be arising out of the course of employment, because you're directing the vaccine. And that's why, by and large, for the flu vaccine, it's totally voluntary. If you want it, fine. So we thought again in November that, overly optimistically, that the vaccine would be able to be distributed more or less the way the flu vaccine is, but I don't think that's going to be happening anytime soon. So as a practical matter, it's all third party. The question, though, is, again, even if it's a third party, whether it's a hospital or the county, whatever, if you require it and the employee does get ill, then that would be arising out of the workplace, out of the course of employment. So I think that's another reason why a lot of employers, both public and private, are trending toward a voluntary program. And then you have sort of like PR issues and things, but at least it gets around that. And it's hard to predict who's going to get that sick. But I think employers are a little nervous and jerky about it.
Steve, you saying something?
Jonathan, I think that, the EEOC has not really carefully given this thought in this sense. If an employer, for example, arranges with a hospital or a local department of health or whatever it is to, even if you call it a so-called contractual relationship, right, John? And the employer, as a result of setting this up, is not going to receive any medical information whatsoever from the administrator of the vaccine, how is that violative of the ADA? I just don't see that.
Yeah,
I
I don't
think
think it
that's the
would.
key, whether or not the employer is going to feedback or not from the administrator of the vaccine.
This program was originally
John, your
supposed to be
thoughts?
South Jersey attorneys, and we changed it, or South Jersey labor relations, and we changed it to this. But it shows you, we have not just intelligent, but humble. I've got a direct message from a South Jersey management attorney, Armando Riccio. He suggests on this topic that what we should do is create a form that simply says, after the employee goes to get the COVID vaccine, and it also only says that they're ineligible if that's the case. So very simple. Here's the form. It says I'm ineligible. You're not entitled to ask me anything else. Make of that what you will. And whether it's mandatory or not mandatory, that's the limit of the information provided to the employer.
I think that's a great suggestion. I commend the person for forwarding that over. Let's try. Let's try a little hypothetical on that one. So, and I've been interested in Steve, your take on this. You're going to have some employees who are going to have the vaccine, some who aren't, whether it's a voluntary program or whether it's mandatory. So then the question is, what, if any, privileges or conditions of employment flow from having the vaccine? So, for example, let's say I have, a trade show in California, and I think it would be better to have vaccinated employees go on a plane and stay in a hotel and work a trade show for several days. So I'm thinking that if it's not a disability related criteria, then I might be able to make decisions as the employer, like travel or even vacations, approval of vacations. I might be able to do that based on whether someone has had the vaccine or not. What do you think?
Steve?
Travel, I'm inclined to agree, because I think that, but not necessarily vacations. I think when you're talking about travel, as in the case of all EEOC issues, safety related issues, even before COVID, the so-called safety defense, you're looking at whether or not the individual poses a threat to themselves, a threat of harm to themselves or others. And I think that it's arguable that as to the travel, the employer could make an objectively reasonable determination, in theory, that a vaccinated person, it's in the employer's best interest to send, and the employee's best interest, and the customers and others that the employee may be working with, that the employee be vaccinated. And in fact, I think you might find some comfort in looking at the EEOC guidance. They seem to be saying to employers that the more that you look, you have a justification based upon the CDC's recommendations and guidelines, the more you can, perhaps veer slightly, not all the way, but slightly from how the EEOC would analyze a typical situation like this with a threat to safety. On the vacation, I think that may be a different story, because with vacation, I don't think the employer bears any responsibility when an employee disregards CDC guidance, for example, and may travel to a state that where there's there's a real cluster, a COVID cluster, a real outbreak. I don't know that I would distinguish between the two scenarios in my mind.
Any retort, John, or do we move on?
No, but I was thinking about the employee who goes to the hotspot, right? Goes to, I came across a New York Times article yesterday or today where there are island resorts that are playing, fast and loose and, trying to get customers. And I know that when we were really in the teeth of the pandemic, when the transmission rate was well over 3-4 to 1. That's when the travel advisory was issued. And it seemed like literally every day that went by, a new state was on that advisory. So we had employers denying vacations based on where the employee would go. Not in great numbers, but it was there. So again, it might have to do with the quarantine as well, but I think that's a good distinction. Clearly, if I'm sending the employee, he's in the course of my employment, she's going to be meeting with customers, dealing with the public, then I'm going to have, and you're right that the EEOC from the beginning mentioned over and over again, we're in a health, public health crisis or emergency. So I think you're absolutely right that they began to expand what employers can do a little bit. And I think the fact that the vaccine is not a medical exam is evidence of that.
Right. For those of you keeping score at home, just because a lot of this is moving fast, John mentioned and gave a little bit of detail about this travel advisory. One of the interesting things that happened in the past year was Governor Murphy, or the state of New Jersey, issued a travel advisory as opposed to an executive order, right? We saw a lot of executive orders, but this was done in the form of a travel advisory. And I believe the language was that the state expects one to quarantine should they go to X state or territory. And this list at first, they tried to use some kind of a scientific basis to keep the list, and states were coming on, coming off, going on, going off. And it ended up becoming so cumbersome that I think the way it ended up in November or so was, so you know what, every state, every territory is basically now a reason to quarantine, or we expect you'll quarantine, whatever that means. However, it's not New York, Pennsylvania, Delaware, or Connecticut. And why these 4 states? Are they because they have low COVID transmission rates? Obviously not. It's just because there are adjoining states. So, I mean, I always found that interesting, or, a little bit humorous, because obviously so much, you could drive to the foothills of Virginia and stay in a cavern and pack all your food and be super careful and not interact with anybody, right? Or you could stay in New Jersey the whole time and be, in downtown Red Bank, or Hoboken or whatever, and, constantly putting yourself in precarious positions, or go to New York City, these other states that are permitted. But that doesn't have to do with the vaccine. So let me get off that digression for a moment. And, Dean, before we get on to, the things we want to still talk about are voluntary programs, religious exemption, things of that nature. But Dean Burrell, one of our board members, asked a question, which I think is really 2 parts. He asks about the negotiability of a mandatory vaccine under the New Jersey Employer-Employee Relations Act, which is governed by PERC, which a lot of the people here who are in the education realm would be subject to, or police officers, anyone in the government sector in New Jersey, state or local government, versus private sector employers that happen to be unionized under the National Labor Relations Act, Labor Management Relations Act. So, obviously, as a baseline, there's a lot more that is negotiable, so to speak, in the private sector than the government sector, because here in the government sector, we've got the ability as employers to say, oh, well, we can make policy determinations, and that takes it out of the realm of negotiations. So the first thing, and I think the school boards looked at this, and Steve, you made some mention of it. The first question that you ask under the famed Local 195 test when you're in the local government sector is, does it intimately affect the work and the welfare of employees? I was actually surprised. I'm pretty sure school boards kind of says that it doesn't. They kind of real quick. I mean, it seems to me that it probably does, because it's the safety and health of employees. Do you want to do a real quick and dirty Local 195 overview of a mandatory flu vaccine, Steve?
Well, I do think that you could make that argument. There hasn't been a lot of PERC case law on health and safety and negotiation of health and safety issues. Believe it or not, I had a case, Mars River, PERC number 8791. It's a 1987 case. One of the few cases that discussed health and safety. I don't know that it really gives an insight, but here's what it says. It says that a union's proposed, and it's on health and safety in general, and has to maybe do more so with employees who have said that they have a fear of going into the workplace because all of the conditions that should be in place, such as ventilation and those kinds of things, are not in place, and that they have a basis to object to the employer's request that they come in. But the case says union's proposal, which would allow employees to refuse job assignments that would endanger their health, safety, or well-being, was mandatorily negotiable, with the proviso that employees could not refuse assignments based on speculation or subjective beliefs, but only on compelling threat to personal welfare. Compelling threat to personal welfare. So, that coin could be flipped a little bit if you think about it, and there could be quite a discussion or debate about, from both sides' interests, what is a compelling threat to personal welfare in the situation where we're talking about vaccinations. I don't know how PERC would come down. That's the first prong. We know that from the second prong, there's no statute, there's no regulation, there's only the governor's executive order. And as I said, it may very well in these circumstances be elevated by a court to be akin to a regulation or that type of thing. And then, of course, would it significantly interfere with the determination of governmental policy? Well, governmental policy is there is a framework that we have from the EEOC, which we've talked a lot about the disability end of it, and at some point we're going to talk about the religious end of it. So there are limits, perhaps, on management's rights, and it may also. I think either you, Jonathan, alluded to it, or you, John, alluded to it, but it may very well depend on the strength of a management rights clause in the public or private sectors, and any health and safety language in a collective bargaining agreement.
I also think it really would be driven by medical evidence, and I just don't think that we have, at least I'm not sure whether we have that evidence just yet, right? Because think of the school board; they're really between a rock and a hard place. How many teachers are calling in sick, for example, right? Is it, they have the current protocols, presumably they're working, split classes, smaller classes, the children stay in one place, and it's the teacher that moves around. Right, so there's a lot of moving targets, so moving pieces. So let's say and targets for that matter, because I think that's what the school board is concerned about, is litigious nature of it. But let's say that the current protocols are working. Then what role does the vaccine have? And what role does the pressure to open up the schools even more so play? So I think when you're talking about policy, you know, you're talking, and as you know, a convergence of all of these things before I think a school board can comfortably say, well, this is health and safety policy. We're going to do it unilaterally. So I see where I see where they want a statute. I really do.
Before we get into the
Yeah.
NLRB piece, I think we should move on to, I think we have a nice segue into the religious exemption, because one concern that I would have in the perk analysis, even once you've done the local 195 balancing test, is that as government, we have employers, you know, you have to consider the constitutional impact on employees more so than in the private sector, right? Because the government is acting under the color of state law. So, you know, I will say, you know, Armando Riccio again put a helpful comment in, which I think answers the part of Dean's question about, to the extent, you know, that these policies are non-negotiable or implemented, then there's effects bargaining. I think what Armando wrote is probably less of a question than something that we can all agree upon, which if somebody has a reaction to the COVID vaccine and the employer is either mandating it or encouraging it in any way, or even if they're not, that there would be I think a negotiable issue about whether employees who take the vaccine should get some sort of a paid status on top of, you know, whatever existing rights that they might have in the collective bargaining or collective negotiations agreement. So rather than beat that one to death, just so we could cover more territory, if it's okay with you, I'd like to move into the religious exemption piece of it, because it's always interesting, you know, there's sort of this anti-vax group of people out in the world who have something against vaccines, but they know that, you know, anti-vax is not a religion, at least as is typically recognized, or, you know, concerns about the vaccine, whether they agree with science or not. So sometimes people have to look for religion. And then there are other people who really do have a deeply held religious belief. I'm going to just real quick show you, this is not a dispositive governmental website, I don't think, but this is Vanderbilt University Medical Center, and they're putting it on their website. And they claim that the following Christian denominations have no theological objection to vaccination. They name almost all of them, right? Amish, Jehovah's Witness, obviously Roman Catholic, Baptist, and the big Protestant faiths. And then they go on and say, you know, in addition, neither do, you know, many of these others. But then there are theological denominations that have objections in some of these more unique groups. You know, one that I always found interesting is the Congregation of Universal Wisdom, which the sacrilege, it shall be a sacrilege to depart from the precepts of the congregation by the following, and it includes the injection in the body of substances, which they claim are unharmonious with nature. This group, of course, is a religion that you can pretty much join by correspondence. You submit a membership application, and you get a certificate letting you know that you're now part of this religion. So, you know,
Can I do a wedding if I join? Would I be allowed to marry people? Do you think?
I don't know. You probably would need to write them and ask.
Okay.
They're where are they located? I think they're not that far away, actually. But in any event, let's talk. I mean, they're in Medford, actually, right by you, Steve.
Right.
So,
Well-
some of that was, you know, not to hopefully, you know, I'm not denigrating any particular religion, but I am, you know, just kind of pointing out that for the most part, it seems that at least with prior vaccines, that when you have to, what do you have to prove, I guess is the question, in order to prove a deeply held religious belief. If for instance, you're Roman Catholic, as probably that's the largest single religious group in New Jersey, and there's not a doctrine in the Roman Catholic Church. Can an individual member of the Roman Catholic faith claim, that they still have a religious objection, even though that's not, what their
Yeah.
clerics are saying?
Well, John recommended to us a book. I'm going to recommend a law review article that one of my associates wrote in law school in the last 2 years on the topic of sincerely held religious belief. His article is entitled Absurdity, Sincerity, Truth, and the Church of the Flying Spaghetti Monster, Title VII Protections and Perceived Satire. So if you want to know about, sincerely held religious beliefs, that'll give you some food for thought. But as you point out, Jonathan, it's an employer really has to tread lightly on that. I know there was a case out of the Southern District of Ohio in 2012, Chinzira, Chenzira versus Cincinnati Children's Hospital Medical Center. The court recognized that veganism in some circumstances may constitute a sincerely held religious belief and exempted an employee from a flu shot requirement. And then I'll contrast that with a very bold employer who took this one on. There's a Third Circuit case that came out in 2017, Fallon versus Mercy Catholic Medical Center, where the court denied a request for exemption, finding that the employee's concerns were really about health effects of the flu vaccine, rather than actually in other words, they were more medical than religious. But from, everything we know, it's something where an employer really has to tread lightly on the issue of what is a sincerely held religious belief.
Yeah, the issue,
at least from my perspective.
No, I agree. So there's Title VII, and then there's the First Amendment constitutional standards. So the problem with the Title VII cases is that most of the reporting cases are either motions to dismiss or summary judgment, where the U.S. district courts are reluctant to, decide. So you'll find that in the posture of those cases, whether it's body piercing, whether it's veganism, whether it's Wicca, or other things that might be outside the mainstream, the courts will deny summary judgment or deny a motion to dismiss because of the posture of the case, and then that case will settle, presumably because there'll be some monetary value or reasonable accommodation. So I agree, tread lightly. With regard to the First Amendment cases, there's a lot of prison cases, praying, foods, and of course, school board cases. And then, going back to those early cases where the police power will outweigh religious observation, religious practice. And in fact, as of January of this year, that flu vaccine that healthcare workers have to get, there's no longer a religious objection. So again, I think a public employer probably has more comfort than a private sector employer, because courts are just reluctant to make controversial summary judgment decisions by saying, veganism as a matter of law is not a religion.
So a small business with 15 or 20 employees where a few of them are wearing spaghetti strainers on their head, they should probably
I
be
think that one,
concerned.
I think that one might be, might be a little outlandish, but you had, KKK, racially offensive tattooing, Confederate flags, Aryan Nation stuff, all of which have been subject to Title VII litigation over the decades, where even U.S. District Court judges with tenure don't want a newspaper article saying that, court finds vegan is not a religion. Denial of summary judgment, case settles.
Right. So let's talk about voluntary vaccination programs. And, this is not the easiest segue at all, but Nancy Carvalho puts in a comment that, hopefully we can maybe use as a segue into the voluntary program, which is we've screened a number of accommodation requests for remote work for individuals in high-risk categories who did not require any accommodations before the pandemic. Since vaccinations do not remove the risk of contracting COVID-19, I guess she means remove it entirely, although I think by science we could say it greatly reduces the risk, doesn't remove it as far as we know, and only reduces the gravity of infection. I think, I'm not sure that that's entirely the case, right? There may be a possibility it reduces the contractiveness, if that's a word, or contractibility. But it says, can employers reasonably require that vaccinated employees return to work on premises if the workplace meets social distancing requirements? So I guess the question is more of a general one, which is that because the vaccine isn't, the cure-all necessarily, does that mean that really, we should still stay locked down?
Yeah, that is the question.
Mm-hmm.
That is the $60,000 question. So we don't know. So when you get your first dose, you get an FAQ, and one of the first things it says is, we don't know whether and how long this is going to work. Something to that effect. I think the presumption of the question, and I think I might have tried to hint at it before, whether the vaccine is it's just one tool in a whole series of other tools. So that I think that if a decision that the employer makes, let's say, okay, you have the vaccine, there's no need for you to work from home anymore, we want you back. I think that all the protocols in place remain in effect. And it's, at some point, whether it's the CDC or some other source, will declare whether it's herd immunity or, I mean, right now the transmission rate is below 1. It hasn't been below 1 since a year ago. So I think, I guess all of that's going to be looked at. And at some point, I don't think the pandemic is ever declared over. I think it's probably declared, and I'm only guessing, that it's in remission, and then it's a slow process of unraveling after that.
We're running low on time, so let me ask Steve a very targeted question. Voluntary policy. So let me just real quick, say that I think that there's some questions under the Patient Protection and Affordable Care Act, popularly known as Obamacare, whether wellness incentive programs could potentially be violative, and that employers have to be careful that if they're making some kind of an incentive program for employees, whereby they get some sort of reward for being vaccinated, that employers have to be careful. And I think there's some jockeying going on with maybe the Congresses or the administrative agencies to try to carve out an exception for this. But I'll put that out there, and then I'll also say, Steve, let's say the possibility, you're again negotiating with me as a management attorney, and we're saying, well, here are two possibilities. Number one, we'll give some sort of a group reward. Let's say the entire unit will receive some sort of a bonus if 90% are vaccinated, or 85%, something like that, versus every employee who's vaccinated will receive $200, or we'll provide an Uber for every employee and a day off, and a gift card or something like that for every employee. Are all of these things okay? Is one preferable to you as a union attorney? What are your thoughts, Steve?
Well, there are, I have a couple of concerns. One is, to what extent can, in a pandemic, can a public sector union bargain with a public employer and waive the individual's rights under the various other laws? That could be an issue. But I do think if you take that out of the equation, if the employer and the union agree to some kind of voluntariness program, it may be something where it would be defensive. Of course, it's hard to know the answer, on so many of these questions, because of, here we are in the middle of a pandemic. But in theory, it might be something that, because there's a voluntary agreement between labor and management over a voluntary program, that it would be acceptable under scrutiny under other laws. Because normally there's only so much that an employer can suggest to be voluntary. But here, things like, for example, giving the time off to get the vaccine, providing, I think it's Target that's doing, is providing transportation, for it, paid time off. I think those things can be utilized, and my gut would be that they would pass muster.
Okay, John, you want to give your overview on voluntary programs and which ones are good?
Well, they're all good. The only question really is whether HIPAA is triggered, and whether you need alternative programs. So a voluntary program that has a de minimis reward, de minimis meaning, $25 or less, you're not going to have a problem. There's no there's no alternative way to get the reward. So for example, because it's not based on a metric, it's not based on a target, as opposed to, let's say, a weight loss program or getting a cholesterol rate. And then you give a big incentive, as you said, the ACA. You can rebate 20%, up to 20% of the healthcare premium that the employee is paying for to hit a target, a health metric. But because it's no longer, because it's based on a health-related reason, health criteria, you have to have an alternative way for other people to get the same reward if they have a medical reason or a disability that they can't hit that target. So I'm having a tough time, to be honest with you, figuring out what the alternative is for someone who can't get the vaccine because of a medical reason. Because you have to give them the same opportunity to get the whatever else you're giving. that's substantial reward. So because I'm having trouble figuring that one out, we're recommending to members that you go with a voluntary program with a de minimis reward and don't have to worry about hitting a healthcare metric or healthcare privacy or having alternatives.
Okay, let's talk if we can for a few minutes about the NLRB precedent with regard to the flu vaccine. So you know, at my prior law firm, we represented St. Barnabas, RWJ Barnabas. And I remember it was a big deal when a case came out, Virginia Mason Medical Center, which basically found that the union had waived their right to bargain over the flu vaccine, a mandatory flu vaccine program, and that it was in the management rights clause. I forgot exactly what the management rights clause says in the Virginia Mason case. I'll give the case site to it after I turn it over for you gentlemen to speak. But you know, John, I remember one of the ones we were looking at, I think that we won an arbitration award on, said something to the effect of, you know, the union agrees that they'll cooperate in any way possible to maximize patient health and safety. And an arbitrator found that that was sufficient for the union to have basically waived its right to any legitimate policy that the hospital or the medical center would implement, including a flu vaccine policy, because patients are so sick, you know, that they could be killed theoretically if they contract the flu, right? I think it's the same thing with COVID. So, I mean, what are we looking at, you think, in management rights clause, and then in the healthcare sector, you know, is that a particularly compelling case as opposed to, you know, say schools or something along those lines?
I really think it's case by case. The other thing is the context. I think the undercurrent is both administratively and judicially, that maybe you give a broader reading to a management's rights provision when there is a palpable public health emergency. So, but I do think this is one where I think you really do have to tread lightly, and I don't think there's any substitute for reviewing the agreement and past practice.
Steve, what about?
Yeah, I think this. I was just going to add that I agree 100% with John that it's going to depend on the facts and circumstances. And we also can't forget the fact that we've operated for a year with no vaccine, and people have been in the workplace. There have been all kinds of efforts made to, you know, social distancing, masking, and all the other things, you know, for a year without any vaccine, and that may play a role too. But you had a question?
I was just, you know, and Dean asks ERISA concerns, which is another good reason for me to spend 4 minutes talking, because ERISA is so complicated. I don't think any of us want to delve into that, but I don't know, maybe you do. Do either one of you want to try to touch ERISA on this, John?
Only to say that the employer should not be the plan administrator, if possible. That'll be. I'll end it at that.
A little bit of background, just for those again who might not be as familiar. ERISA is the law, Employee Retirement Income Security Act, something along those lines. You know, it was designed obviously to control pension plans, but also controls health and welfare plans, predominantly in the private sector, a very highly regulated area of the law, and there are attorneys who do nothing but ERISA law, and those are the ones who we frequently go to when a thorny ERISA issue comes up, and that doesn't apply in the public sector generally, but it is something that you need to be mindful of anytime you're implementing anything that could be construed as a benefit plan or changing a benefit plan. So The last topic that we were going to talk about is what kind of leave is available for employees who have side effects from the vaccine. I think John started to talk about this a little bit, but why don't we see if there's anything else out there? I don't know, Steve, how familiar you are with, the workers' compensation scheme, unemployment. Would any of these things provide, let's say you used your 12 weeks of FCRA or FFCRA time, your employer's on a fiscal year basis. So you used it somehow, between, September or August and December 31. And now your employer is telling you you're out of FMLA time. You're out of, what alternatives are there that might be available?
As far, well,
Go ahead. Sorry, Steve.
go ahead.
Now, I was just going to
No, go ahead.
I was going to state the two obvious ones, which would be New Jersey earned sick leave,
Mhm.
and depending on the length of the illness, short-term disability insurance.
Anything, Steve, on that?
Yeah, no, only if there's any kind of contractual leave or policy that you can, hook into. Because although the administration of the vaccination doesn't trigger a medical issue, the side effects do and could be treated the same as any other, illness. For example, by analogy, pregnancy is not considered a disability under ADA, but any, illnesses or medical conditions that arise separate and apart from the pregnancy could be covered under ADA. So I could see by analogy that you could say that if somebody is vaccinated and has a adverse reaction, gets, sick and needs time off, that they should be able to utilize whatever types of leave are available, or at least in the public sector, it might, this whole thing, this whole pandemic situation has triggered some efforts to negotiate a whole host of things mid-contract that people on both sides never ever thought about. So you could have that as well. There could be a discussion about that. But outside of that, it's what John has mentioned, and anything that could be available under the employer's policy or a collective bargaining agreement.
I'll put you on the spot here. What if I work for an employer who does administer the COVID vaccine on site, and I get the COVID vaccine at work? Is that a workers' compensation? Is that something that I've therefore, become exposed to as a result of my job, whereby I could get workers' compensation coverage? Does anybody think that?
Oh, yeah. I think the question in the chat as well, with regard to whether it's correct me if I'm wrong, but there's a waiting period for workers' comp. And so if you're going to have a reaction, the routine reaction to the second dose is, you're tired the next day and you may not feel like, going in. So that's going to be a sick day. If, though, you are ill for a period of time, then again, short-term disability insurance, which does no longer have a waiting week, would apply. If your employer is requiring the vaccine and you get seriously ill, then that's a work-related, that's a work injury or work-related illness.
One thing, Brady Connaughton direct messaged me about the workers' comp amendment that first responders who contract COVID and have a rebuttable presumption that they got in the workplace. I'll just give a funny comment on that. I don't know if it's funny, really, not if it happens to you, but what I've seen from my clients, we represent some fire districts. I had one fire district where everybody wanted this firefighter to get the workers' comp, the entire board of fire commissioners. Yet the insurance company did what insurance companies always do, and they denied coverage. They came back and they said, Jonathan, write them a letter. Yeah, there's a rebuttable presumption. Well, doesn't that mean anything? No, it's denied. It's denied. Let them prove it, right? So I mean, so far I haven't seen that insurance companies act any differently under.
The key word is rebuttable.
Yeah,
And
right.
and that's
Right.
the real fight that's going on now, right? Because the commercial carriers don't want to pay the claim, and they're scrutinizing these claims. And I know that the major carriers have like war rooms, right? Looking at these claims and trying to get them over on the workers, send them over to the workers' comp carrier.
Yeah, I doubt the legislature thought that it would be that
I
way,
told
but
I
that's how
told
it's
them.
happened.
A lot of people told them. The other thing too is that the reason why the workers' comp carriers are fighting tooth and nail is they can't pass the costs on to the employer.
Right,
It doesn't go to it doesn't go to
their experience
the
rating.
rating.
That's
Yeah.
the rate.
Right. Well,
So-
it's 8:35 and we were supposed to be done at 8:30. I feel like we could easily go on for probably another half an hour. But we have reached the end. I think it's only fair though to give Steve a chance to wrap up and maybe John, if you want to say some parting words before we bid everyone adieu. Steve, you want to start?
No, I would just say, that if anybody is really looking for some, black and white answer on any of these issues, you're not going to find them. Even, the overlay of the pandemic has caused all kinds of adjustments by courts, by administrative agencies. The EEOC is taking some of its more rigid positions and saying, well, if the CDC or your state or local Department of Health says that that a certain way of proceeding is okay, they seem to be hinting they would abide by it. So I think, as always, it's going to come down to the facts and circumstances. And as far as all the legal issues, as they used to say on Star Trek, we're going to have to boldly go where no one has gone before.
Indeed. John, any closing remarks?
Other than I concur wholeheartedly with those closing remarks. And it's certainly been a pleasure to be with the group, and I'm delighted that you asked me.
Great. Thank you so much to both of you. I think hopefully everyone who's in the audience enjoyed it as much as I did. Just so you know, our last meeting of the year is coming up on May 3rd, first Monday of the month, which is what we usually try to do. The topic is going to be diversity in ADR practitioners. I know Ken Eggers, I believe, and Pat Westerkamp, I think, are working on that. And we should have some diversity on the panel talking about the diversity of ADR, which is something that is of interest. It's been done by a lot of groups, but we're going to try to do it the LERA way and talk about what's being done, what can be done to increase diversity in this space, have it be less heterosexual white men, and so some more diversity in that group. So that's something we encourage everybody to sign up for and attend. And that will also be when the election is held on the slate that Bill Dwyer announced earlier. So thank you everybody for coming out. If you want to stick around and accost us before we leave, you can try, if you could get us before we go. But I'll ask Bernadette to stop the recording, and I thank everybody for being here, and thank National LERA. Thank